then you can be under arrest.
If you are going to threaten us with physical violence, you better make sure you're willing to go all the way, because I am.
The way the law works is if the law doesn't say you can't do it, then you can do it.
If you want to lock people up for not breaking laws,
all men are created equal is the idea that if it is wrong for one man to commit an act, it is wrong for all men to commit that act. Too often, members of our government exclude themselves from the ranks of equal men referenced by Thomas Jefferson when he's...
Hello, everybody. Welcome back to another Craig Henry live stream. If everybody could do me a favor and drop in the comment section if you can hear me all right, that would do me a big favor. So today we are here to discuss a summons that I received in the mail, and we're going to get right into it, everybody. So basically, some background. I had a pro se motion to dismiss hearing on July 2nd. I received a copy of an audio recording from an anonymous source, and I then published that recording because it certainly is a matter of public interest. I mean, thousands of people have followed this case from the beginning to its current status, and so it's clearly a matter of public interest. I published it for you, and what I received in the mail, I am about to show you. So, let me see here. All right, looks like we're showing you just fine. I'm going to get this out of here. I know we got two screens, but that's because I've got a weird setup going on here. So I'm just going to make sure that I'm showing you all. Yep, everybody can see it. This is the summons that I received, everybody. Now, this is a motion for a rule to show cause. This is what the prosecutor filed with the clerk of courts. So we're going to get right into it. He says, the undersigned, having affirmed, says that between July 2nd, 2024 and July 6th, 2024, in Greene County, state of Indiana, Craig Robert Henry did willfully disobey a process or order lawfully issued by the Greene County Superior Court, or did willfully resist, hinder, or delay the execution of any lawful process or order the Greene Superior Court to wit. So he's saying in this, he's saying that I violated something that the Greene Superior Court put into place. So Craig Robert Henry recorded or aided in the recording of the hearing in case 28D01-2403-CM-00097 in Greene Superior Court held on July 2nd, 2024 by use of an audio recording device, and then published and broadcasted that audio recording on July 6th, 2024 to his YouTube channel, Henry, in a video titled Pro Se Motion to Dismiss Hearing, without first seeking consent of the Greene Superior Court. These actions are violations of Greene County Local Rule LR 28-AR-00-09G and Indiana Code of Judicial Conduct Rule 2.17. Further, the state alleges that said act was a deliberate intention to defy the authority of the court, all of which is contrary to the form of the statute in such cases made and provided by IC Code 34-47-3-1 and IC Code 34-47-3-2. So there are two provisions of that code that he is alleging that I violate. Now, we're going to get into that. We're going to look at the code a little bit. But what the main thing that everybody should take away from this is that this is a criminal allegation. He has written up an affidavit, and you don't even know who it is yet because I haven't shown you the second page. So we're going to show you that. Let me see. I believe this is it right here. This is it. So this is the second page of his affidavit. He goes, therefore, the state now asks that a rule be issued ordering Craig Robert Henry to appear and show cause why he should not be punished for indirect contempt of court. I affirm under the penalty of perjury that the foregoing representations are true. Signed by Brent W. Seymour. And that is the corrupt prosecutor that's been maliciously prosecuting me in this county for a few months now, for it looks like 4 months now. So this guy has been out to get me from the jump. I mean, we're going to play it. Matter of fact, we're going to show you the audio recording that this guy is so worked up over. Here we go. I'll get into it right here. Now, this is just the pertinent part of it. I start, as you can see, 22 minutes in. We're actually going to adjust the share screen because you can't hear the audio in this. I'm going to put myself back up on the screen. All right. So I hope we're all ready to hear this audio recording. This audio is an excerpt from the video pro se motion to dismiss hearing that I shared on YouTube. This here is the final part of my argument in the verbal argument stage, and then the prosecutor's response, and then my response. And we're not going to listen to the whole thing. I'm going to kind of fast forward through a few of the bits. But let's see. As a matter of fact, I am going to just skip to the very, very end. I thought this was the end, but this is the very end of it. I guess I talked for 26 minutes or so. So here we go. We're starting here.
The only charge that the defense contends that zero probable cause existed, and I say zero because I mean zero, was this resisting law enforcement. But damages have been sustained by the defense simply because it was charged to me so frivolously. And the other court basically viewed it in the light most favorable to the state, as I contend most courts do. I was forced to sit for 11 days in a county jail, in Vermilion County Jail, as a result of this charge being brought against me, when no forcible element was met. No forcible element could be seen by a reasonable person to have existed in this case. So I guess with that, I'll wrap it up. I just wanted to make it very clear the defense suffered exorbitant damages as a result of this. The defense still suffers damages. Writing up this stuff is not a easy or simple thing to do, as I'm sure the court knows. So with that being said, thank you very much for hearing me, Your Honor. I would like to deliver 4 separate pieces of case law to the court.
The state was to respond.
Yes, Your Honor. Yes, I would start with Mr. Hendry's last point as to the reason why he was revoked in, I think it was Vermilion County. The judge actually never ruled on the state's first motion to revoke bond, which was based on the Class A misdemeanor. The Vermilion County Court only ruled on the state's second motion, which only referenced the Class C misdemeanor, which is not the reason that we're here for today. So that is a non-issue as far as the state's concerned. The defendant also, frankly, misstated the law. The case law is clear that there's no requirement of physical contact, and I think that that is in the double check just so I don't misspeak here. Well, City of Hobart.
Just so that anybody new to this is the hearing, this is the audio recording that I received the summons for. So we're going to continue on. This is the prosecution.
Indicates that, and specifically, I finally found it, Walker versus State, which is 99 Northeast 2nd, which I referenced in my briefs, 2013 Indiana Supreme Court case. It held that the Supreme Court has never held that actual physical contact between the defendant and officer is required to sustain a conviction for resisting law enforcement. Excuse me. The definition of force and forcible that Mr. Hendry was using is the Spangler definition, I believe. The court goes on to say that the line after Spangler, the court goes on to say in Marcy versus State that the definition of forcibly, and I would contend forcible as well, has been slightly softened since Spangler was decided, and the line between what is and is not forcible resistance is blurry, to say the least. So the contention by the defense that there's a hardline rule on what force is and what it is not is simply untrue. As far as power or force and the defendant's contention that light does not have mass, so therefore it does not have force, I believe is is the logical progression that he made. The state would introduce the mere idea of a laser. There are crimes specifically about pointing lasers in people's eyes in airplanes. And so the fact that there is no source of light that could reach the level of force requisite for this statute is incredible, unbelievable. More specifically related to this situation, Mr. Hendry injected himself into this situation. He was not the subject of the stop. This interaction was not based on his behavior initially. He happened upon it by whatever means it is that he happens upon these things, and inserted himself into the situation, which he may have a constitutional right to do, but he does not have a constitutional right to interfere with the law enforcement activity. On to the use of his body. I think that Mr. Hendry today admitted to this court that he did use his body to point that flashlight, which could be construed by a court not necessarily this court, or another finder of fact as using force to obstruct. I'm not asking the court to do that today, obviously. This is not a fact-finding hearing. But it is certainly a reasonable conclusion that a finder of fact could reach. In addition to all of that, this court found probable cause for the filing of these charges at the time that they were filed or shortly thereafter. And for those reasons, the reasons that I had just mentioned, the state believes that this prosecution should be ongoing at this time and would ask this court to find in favor of the state in regards to this defendant's motion.
Your Honor, do I have permission to speak? Yeah. So, physical contact required. Mr. Brent Seymour made the claim that I made the claim that physical contact is required. I did not make that claim. I made the claim that physical contact and I made that very clear, or a threat of strength, power, or violence is required. Mr. Seymour completely went over that point of my talk. Completely skipped over that, because if the court actually considers the fact that it's not a use of physical contact that the defense is claiming to require, but a physical contact or a threat of strength, violence, or power, that's what's required. I didn't make the claim that it was physical contact. So Mr. Seymour belaboring the point that there's case law that says that physical contact is required is curious to me. Forcible, while there may be a case that says that the definition has been slightly softened, the definition has been reinforced time and time again. Go back to my point. Physical contact required or strength, violence, and power. I believe that's the Walker court. I believe it's also the Pogue court. So I don't know exactly what the state is getting at when he keeps belaboring that point. Then the state goes on to talk about laser beams. I don't know where I get a laser beam capable of, I don't know. I've never personally seen one, but All right, everybody. So that is the majority of the hearing. That's the majority of my response. If anybody is interested in hearing the rest of my response, I want to encourage you to go and watch the pro se motion to dismiss hearing that is on this channel. It's in the videos page on my channel. But we have a guest. We've got for public safety up. I am actually going to include a link to the StreamYard in the chat, and I'm going to do that so that other people can join us. Let's see. There we go. Thank you, Bob Lau, with that super sticker. I'm going to put this link in the chat so that other people can come up and join us. What we're going to do for public safety, if you can say hi to us, let us know that you're here.
What's up, Craig? How you doing, chat?
All right. That's great. Thanks for being here, man. It's great to have you up.
No, I appreciate it. It's been a while since we've been on panel together.
Absolutely. It's been too long. It's too hectic out around here for guys like us nowadays.
This area seems to be a little bit angry at the Constitution lately.
Oh yeah. Well, the hatred for it is palpable. You can literally feel it if you try to challenge in any way these people's constitutional violations.
Oh yeah, you can definitely feel it. The mats that they put you on in the jail are thin.
Oh yeah. Oh yeah. And they got new ones. You always see the new ones in the closet, but they never
Right,
come
yeah,
out.
they
I
don't
wonder
give
what
them
they
to
do. They
people.
must take a steamroller and roll over them before they give them to an inmate. You know. So, but anyways, what I want to do is I want to watch something with you. We heard the prosecution argue that what I did was, forcible and all this, but it's quite funny. I've actually got a video right now that we can look at and we can assess whether I did anything forcible right here and right now. And I figure, why not do it? Let's be transparent. So I'm going to put it up on the screen here, if I can get it up. Here we go. I'm going to give us this layout here. All right, everybody. So this is what the cop is saying is forcible. Now I'm going to give you a little context. The guy in that truck in front of the cop car, he's gone. He's done walked away. All right. The traffic stop is at this point concluded. The cop has called a tow truck driver to come and collect that truck in front of his car, and he's just sitting there waiting. And this is what's going on here. Do you kind of see what he's talking about there, Chris?
Well, I see his lights piercing holes through a truck. Like that truck's going to get obliterated here in a moment from those lights.
Oh man! And by the way, when I step in front of him, he's got these lights. They're not his headlights, but they're these overhead lights right above his windshield, and they're shining right in my eyes. I couldn't see a thing.
I don't know how you live through it, according to the prosecutor's thoughts on what light does.
Yeah, well, I mean, it's obviously, like you say, it's about to puncture holes through that metal that the truck is made of. And of course, I mean, when I stepped in front of it, I was about ready to sue for excessive force. You know what I mean?
Well, what is that, a Chevy? Is that a Chevy?
It's a Ford.
Somebody needs to start a Ford safety program, for Ford
Absolutely.
safety.
Absolutely. Yeah, that officer is really endangering that Ford safety. But we're going to continue on in this video because I believe that there's another light beam that is shined. So let's keep going.
Oh man, he is not happy about this. I just gotta see. I think there's somebody in the passenger seat.
There is, bro. I saw him.
You see him?
I did see him.
I don't know if they're the suspect though, or if it's another police officer.
Yeah.
It's hard to tell.
Couldn't tell.
It really could be a suspect considering that there is a car there, but we don't know what's going on.
By the way, this footage is being recorded by Ty, who is in the chat. Is Ty Reviews. So if anybody is missing him, anybody wants to see what he's doing, he's making great content over on his channel. Go over there and check him out.
It's a safety issue. I'm asking you to stop. What's the safety issue? Shining a light in my eyes. You take the light out of my eyes? No, you can leave the traffic stop. I'm doing that for a particular purpose. For what purpose? It's none of your business. But I'm telling you. Is it against the law for me to shine it in your eyes? I'm telling you, you're interfering with my traffic stop, and I'm going to forward it to the prosecutor, and we'll see if he thinks it's against the law for you obstructing. What are you going to do if I shine the light in your view? I'm telling you to stop. What are you going to do? Are you threatening me with arrest? I'd like due warning, you stupid pig.
All right. And, that is essentially the totality of the events that occurred with this traffic stop here. I'm going to put this back. I'm going to see if I can't get a new layout going on. But, yeah, I mean, for public safety, what do you make of that, man? Did you see a forcible action on anybody's part there?
Well, I just wonder why the prosecutor isn't charging for what he really means. The charge that he wants to give you is for saying stupid pig. That's what they're mad about.
That's an interesting take. To be honest, I hadn't thought of it like that before. I didn't think that they would be that worked up about it. But that is certainly an interesting take.
Just ask Chili.
Yeah, I mean, clearly it happened to him. That's for sure. That's great. Yeah, and I could see that. I wonder what the chat thinks about that. I think that the prosecutor is clutching at straws when he comes up with this absolute nonsense to say in court. I don't know what the judge's decision is going to be on that hearing, but it will come on. I believe it'll come on September 2nd. I believe that'll be 60 days after it. So,
well, I think you clearly have a great argument for the case. I don't think the case is solid at all. I think that's part of the reason for the retaliation that you're experiencing now. What I'm learning, and probably, what your thoughts were for bringing me to the stream, was also what you're thinking is, we're experiencing a similar thing, you and I, in that when we publish for the world to see a case where they're not solid, it's embarrassing to them, and they want to at all costs remove it from the public perception, is what I think. So, I think what we're witnessing here is a desperate prosecutor who's embarrassed at even trying to take action on such a weak, ridiculous case. And yeah, I mean, you made a fool of him in the courtroom, Craig. The argument, I watched it, and I was literally laughing. I was laughing at how well you established the argument against, it was a dumb argument on the prosecutor's part. Like, he's trying to say that the light, when he got to the point where he was talking about lasers, I busted out laughing like I was spit coffee.
Yeah.
I was like, really, dude? This isn't Star Wars. Like, what are you watching on television to make you think that the light was going to pierce and cut the cop in half? I mean,
I agree. I think it's ridiculous. I think that in any way that they're saying that it could be interpreted as force is just clearly wrong. I mean, there were people even that supported me that were saying, "Oh, well, a laser could be seen as force because energy and mass, energy equals mass." I guess their argument. That is I guess E equals mc squared. But I think that there is a difference between thermal energy and kinetic energy, and I think that the level of light requisite to pierce something or to generate a level of thermal energy that could cut something or damage somebody is too powerful to even comprehend for a flashlight.
Well, let's put it this way. If there were such a tool available to be purchased by the public, there would be strict standards put on the manufacturer of the distribution and sale of the item. And there would be laws specific to that item. So, I mean, to suggest that your store purchased, no rules apply flashlight. I mean, the only rules are make sure that the positive and negative are in the right position when you install the battery.
Yeah. Yeah. I managed to get that one right.
Dangerous if you don't point this at anyone. I mean,
No, and as a matter of fact, it's a relatively low-powered flashlight. Most cops are issued a flashlight that is at least 2 times more powerful than that, and at least 6 times more powerful than the setting that the light was on when the guy even got it shined at him. Because it was
right.
1,000 lumens. Most cops' flashlights are 6,000 lumens at the least, and they're extremely powerful.
I want to put this out there just to prove how non-biased I am to these types of cases. I like to be realistic. I mean, because isn't that what the reasonable clause means, to be realistic about stuff in this case? But like if we were comparing it to another case where shining a light in a cop's eyes might be an issue, what if a cop was like taking aim on a suspect who's shooting at them and you shine a flashlight in their eyes while they're trying to do that? Yeah, I can see the problem, but when you're sitting your donut eating ass in your car waiting on a tow truck and a light comes through your heavily tinted window, which it didn't even look like it reflected where the officer's actual face was. I would argue that it even hit him in the face, like he claimed. But even if it did, who gives a shit? I mean, you're not putting him in any type of jeopardy whatsoever. Maybe he got some of the glaze from the donut on his lap.
Well, he said, I believe in his affidavit, he said that he had a female officer along with him in the car. Now, I seriously, genuinely do not mean to insinuate anything at all by saying that it was a female officer. I just mean that is what he said in his report. Now, I don't know how he would feel unsecure or unsafe if he had a whole nother officer along with him.
Maybe he was trying to say that it hurt her feelings, and he's a big man and is going to press charges.
Yeah, it was a curious thing to me. I see. I just logged onto my Gmail and I saw a Gmail from Wanda Mize, who is in the chat, I believe. Wanda, I dropped a StreamYard link. If you want to join, you are welcome to come on here. I'll have to fix your comments. There was actually a troll who infiltrated me, my channel so far that he got a member, or not a membership, but they got an admin, right, where they could delete comments and actually restrict people. And so they started restricting all of the people that loved the channel, and they started, only letting trolls comment for a while. So a lot of the people that used to comment have actually been restricted, and I apologize for that.
No, that's a dumb game.
Yeah, it's ridiculous, man. But yeah, I was trying to bring up the prosecutor's response here because he actually says that a light is it's a threat, is what he says, and I've got it up here, and I'm going to show everybody as soon as I get back onto the StreamYard.
Does that just pertain to the night shift?
I don't know. I really don't know. I'm going to have to ask him about that at the next hearing, I think.
They might need to put a few day shift officers on night and see if they melt.
Yeah, because heat from the flashlight. But here we go. I don't know if anybody can see it. I'm trying to try to adjust it a little bit here. That's not making it any better. There. Okay. So this is the prosecutor's response. So at first he admits, because at the first hearing I go, look, isn't this a forcible offense? And the prosecutor goes, oh no, this isn't a forcible offense. Forcibly only applies to the verb resist. The verbs obstruct and interferes. They don't need a forcible element. And I said to him, I said, look, that's ridiculous. The English language is clear. I mean, when there's commas saying, forcibly resist, comma, obstruct, comma, and interferes, those commas are to congregate those verbs and say that all three of them have to be forcible. And I was right. I checked it. And I said that to him in my motion. And he goes, the state, through the undersigned deputy prosecuting attorney, attempted to answer the questions posed by the defendant to the best of their knowledge and ability at the time of the initial hearing. And that through the research conducted in the time between that hearing and the time of the filing of this response, the state, through the undersigned deputy prosecuting attorney, realized that he was fucking wrong and that I was right. And that he probably should go back to law school. But we're going to go back. We're going to go down in this motion of his, in this response of his, because he writes up a 4-page response. I mean, he acts like, it's no issue, but he actually does need to write up a 4-page response to get to.
Maybe he's one of those lawyers that are cheating and using Chat GPT.
He might be. I mean, this looks as so ridiculous that he said, come up with the best plausible argument to this. But okay, so he goes right here. He goes, what?
4 pages is excessive.
Oh my goodness. I mean, and his point is just, he didn't even get his point across in it. But he goes, the state would also posit that shining a flashlight in a manner that obscures or obstructs the vision of an officer could be construed as, quote, a threatening gesture or movement, or otherwise presents an imminent danger of bodily injury, unquote, which has been established as Tyson versus State. If an officer at night has his ability to see obstructed, they cannot see what or who may be near or what they may be doing. This is a direct threat to, you guessed it, officer safety that potentially places the officer in imminent danger. And of course, I said to the judge in the hearing, I said, Judge, I would encourage the court to deal in the realms of reality here. And yeah, I don't know if they're. Well,
hold on, I mean, benefit of doubt here. I don't dislike that case law on the subject. Like I mentioned earlier, let's say you're shining a flashlight in an officer's eyes who's trying to return fire. That case law would be completely relevant for that argument. But the way he's putting it into your case, trying to apply it to the case at hand, is the problem. Because
and I would say that you're having to, if you want to use that in any kind of way relevant to the statute, there would have to be severe accompanying factors.
Yeah, there's got to be something that ties it to the situation at hand. And it,
right.
Just because the light is mentioned in the case doesn't mean, he's grasping at straws is what I'm saying. He's grasping at straws by pulling out an irrelevant, it's a relevant case law to light, to a flashlight or whatever, or a bright light being shown in the officer's eyes, but it's not relevant to your case because there are no factors of officer safety. That's where he's kind of, misfiring here. And I think his purpose is obvious, is that, he's desperate because it's a weak, ridiculous case.
Yeah, I actually went and tried to talk to him the other day. Me and Tyler went to the Greene County Courthouse because we were interested in the order that I received, which I am actually going to show because I haven't shown it yet. This is the 3rd page that was attached to the order, the summons that I received. So let's see. I'm going to have to share the entire screen here. If I can. There we go.
Just so you know, Craig, I'm using my phone, so reading the lettering on anything for me is a no-go. You just have to.
Okay. All right. I'm going to make sure that we can even see the screen here. I'm going to try to just go full screen with it. We will go down. All right. So this is it. Summons to appear in person. So they go, You are hereby summoned to appear before the above designated court for a hearing on a motion for rule to show cause at the second floor courthouse. At second floor courthouse. Hold on, I didn't exactly catch this. This is very important, Chris. I don't know if you're catching this. I am not. So, okay. It's the above designated court. Okay. So they just want me to go to they want me to go to the Green Superior Court, but there's no judge's signature attached, which is very confusing. So you commented, you said you think I do have to go, but the only signature of any public official that's issued to me is Stuart Dowder, who's the clerk. And he says, if you do not so appear, an application may be made for the issuance of a warrant for your arrest.
Yeah, judge's discretion. I mean, so you already have a judge, and as I understand, or if I understand, a motion, rule to show cause is where, because I'm doing this with Tiffany's ex-husband right now. Tiffany and I have filed a motion to show cause in the protective order hearings. And, when you file that motion, it's in your case that's pre-existing, and it's just to like make the judge aware, hey, we think someone on the other party is violating your court rules on this, and we would like for you to hear it. So yeah, I mean, yeah, I think if there's been a motion to show cause applies in your case, if it's been filed, I would, I mean, I think you should always show up for court when you have a court date. I mean, I wouldn't test. If it was me, I wouldn't test it. I would go, and that's where you get to go and have your argument. If you're innocent, like, I mean, I don't even think that they'd make it that big of a deal. Like, from one state to the next, these recording court proceedings are all over the place. I mean, in Kentucky, you can order the video footage with audio, directly after, like within the same minute of ending your hearing, as long as it was a public hearing. And I'm pretty sure Indiana's the same as far as criminal hearings are public. So
it's actually not. It's insane. I mean, and I'm gonna let you know and everybody else know, Indiana does care about this. This is a massive, massive deal. Indiana has just recently reevaluated and rewritten Rule 2.17. They left it up to the judge's discretion, which it previously was not interpreted to be. It was interpreted as a judge shall do this. Now it's a judge may do this, from what I understand. But they do really care, because when you go to request any records from the court as far as a record of a hearing, what they want you to do is they want you, and they're adamant about this. It's the courts, by the way. They decide what they have to do. No other
transcript.
They make you buy the transcript, but there's an Indiana law that says if you want to get a transcript, you have to pay a court reporter after hours. So she's not allowed to do it by law while she's on the clock, or while he's on the clock. They have to have this this public official, this court reporter, go home, and you are stuck with the bill. So if it takes them like 8 hours to transcribe a 3-hour hearing, or heck, that would be a great transcriber. But you'd have to pay him like $60 an hour to do all of it. And if you try to get an audio recording, they say, well, the Indiana Supreme Court is the only one that has access to the recordings. You'd have to go to them if you want to get the audio, and try to get before the Indiana Supreme Court. It's very, I mean, could you imagine it? It would be extremely difficult.
Yeah, I mean, I paid for, through our lawsuit, we just had to pay for, that process to be done in our interrogatory, or in our what was it?
Yeah, interrogatories.
Yeah, and I mean, it's not cheap. That's for sure.
Yeah, I mean, yeah, you can attest to it. It's definitely not cheap. So now I'm going to look at, for anybody who's been kind of following along with us the whole time. If anybody's been following along with us the whole time, put a 1 in the chat. That way I know who's really been here with us. And if you haven't been here, don't worry. You can go back and check it out. This has been a very consumable video. I am going to show now on the screen the Indiana code that the prosecutor was citing in his motion to show cause. So I'm going to read it out. So this is one of them. It goes, resisting or delaying process. It goes, section 2, a person who willfully resists, hinders, or delays the execution of any lawful process or order of any court of record is guilty of an indirect contempt of court. So I don't know how I resisted, hindered, or delayed anything. Okay.
What did it say? Resist a process?
It goes, resists, hinders, or delays the execution of any lawful process or order of any court of record is guilty of an indirect contempt of court.
Okay, so the keyword's execution.
Yeah, delays the execution of any lawful process. I think lawful is another keyword as well.
It is. I just want to focus on that execution part because that would apply in the courtroom, I would think,
yes.
Or at least, like we can't do our job if this thing happens.
Yeah, like what order were you trying to execute, and I hindered, resisted, or delayed it?
The question has to be: does this prosecutor, is he actually this ignorant to understanding verbiage applies in law, or is he retaliating? Like that's the question.
Yeah, I think that it's a question that we're going to ask in court too. I think that it's a very relevant question. This is the other section that he is accusing me of breaking, and he wants me to come in for this motion, for this rule to show cause hearing, and he wants me to explain why he shouldn't file to have me arrested for this. So it goes, a person who is guilty of any willful disobedience of any process or any order lawfully issued, one by any court of record or by the proper officer of the court. 2, under the authority of law or the direction of the court, and after the process or order. And so this is a key word to this. And after the process or order has been served upon the person, is guilty of an indirect contempt of court that issued the process or order. All right.
I mean, on that one, he's got a better argument. I'm not saying he's right or wrong.
Well, and I think "and" is the key word.
Yeah,
because I'm going to come full disclosure. Nobody ordered me to do anything, and this is a requisite of this code. It goes, and after the process or order has been served upon the person. Well, this doesn't apply to me. I can tell everybody that no process or order was served upon me about publishing media of public interest. So I think his argument is exceptionally weak on this point in particular. That's my perspective on this.
I wonder this. Let's say you went straight from the courtroom to the clerk's office and requested the transcript, or if they had an audio, which a lot of them do have audio, most of them do have audio, instead of charging you to type everything out or whatever they call it, stenography or whatever. I don't think they even do that anymore. I think most courts have gone to all the way audio. And let's say you received it between then and the time you were able to publish the video. What if you had published that? Would that have been a problem for the prosecutor?
Yeah, it's an interesting take, and I wonder what the problem really stems from, because nothing was hindered, delayed, or obstructed.
Right. We can establish that.
Yeah, by the public hearing what happened in a courtroom, in a publicly accessible courtroom at that. That doesn't hinder anything. As a matter of fact, that if anything, it amplifies transparency, which everybody knows is a benefit. So I think that's kind of ridiculous. And then, if the judge wanted to order me to do something, she's got the power to order me to do something, but she never did.
Like in one of my hearings recently, the judge clearly said, I asked the judge if I could audio record. And her answer was no, because it was not a public hearing, and I didn't put in early enough for her to establish, some factors to it. So, which I've completely respected. I just wanted to have a copy of it for myself because of the issue at hand was ongoing, and I wanted to be able to prove whatever was said in that room from the minute I left, not necessarily have to wait on records to come. So, and it ended up being I had to wait on records to come. And yes, the court order, the protective order was violated within an hour after we left the courtroom. So it would have been handy to have that recording because I could have, let the sheriff hear what the judge had issued. But anyway, it goes. I just don't. I'm torn on what the problem really is because, like I said, if it's public hearing, and I'm not a lawyer, so I mean, I can't help with like an argument at all, but I'm trying to just be reasonable about it, understanding the process and going, what's this prosecutor's problem? Like, I mean, I get why I filed a motion to show cause in the protective order case. It's because the protective order was violated.
Right.
But what's his problem? I mean, why would you go through the trouble of? I just don't get it because if you did get the records, which you very well could have. I mean, if you had a good, speedy clerk and they had no problem with transparency and all the stars were to align with their backlog, you could have gotten that audio recording within, a day or two and easily had every right to publish it on your channel, as far as I know. But in my case, the judge specifically said, don't do that. And to me, that's an order that I received in my case, in my hearing, right? If the judge didn't do that with you, then I don't know how you would be in direct, contempt of that rule.
Yeah, or indirect contempt of court, because there has to be like it says, it has to be an order lawfully issued by the court or an officer of the court.
But he's going to have to prove that you directly went against a court rule. So yeah, an indirect means it happened outside of court, while you were waiting, but directly he'll have to prove that you violated a court rule. And I don't know, Indiana is pretty strict and tight on the recording in the courtrooms. I don't know why. It's obviously a far cry different from Kentucky because you see how easily and quickly my hearings go up online, literally stalkers following me while harassing and videoing into the courtroom through the doors, and nothing happens to them in Kentucky. But
yes,
I mean, Indiana's different. I get that. I just,
now,
if
Kentucky, as far as transparency in the courtroom, in the state courtrooms, they seem fantastic. I believe, like you say, it's correct. It's state law for them to do it. Indiana doesn't want that, and there's a few reasons for that. I mean, I'll just give it to you straight. Let's look at this, and I believe that there is some correlation and causation here. So I had one case in Kentucky. We got a real lawyer on it, and the case was essentially dismissed without any more. I mean, the prosecutor was begging us to let him dismiss it. He was like not wanting us to go to trial at all. He was like, look, I'll just dismiss it if you wait 180 days. You don't have to do anything. And then he agreed to it. It was crazy. And in Indiana, and I believe that the reason that he did that is because he knew that hundreds of thousands of people were going to see what he did in that courtroom. Yeah. But in Indiana, these prosecutors operate covertly. They don't need to worry about the public seeing them at all. They know that the public will never see them. As a matter of fact, the public knows that they'll only ever see the police. And the judges know. The judges, Chris, they also know that the public will never see it. This is the reality that we live in, and they love it. They love it to be this way. They hate the transparency. Not everybody. But you'll notice that all around Indiana courtrooms, there are signs up all over courtrooms saying Rule 2.17, no audio video recording.
Mm-hmm. There's
a few courts that don't have that. This court happened to be one of those courts that just didn't have that. The court never issued an order.
Yeah, what's interesting to me is, it also says no food or drinks, but they're so worried about the audio recording that they'll frisk your pockets and let you walk by with a big gulp.
Right. Yeah, exactly. And I mean, they'll only worry about the big gulp if you got them on camera.
Right.
That's the truth. But I think the Indiana court system, I think that it needs some work, man. I think that the judges need to run on transparency here. I don't see any reason why they shouldn't be transparent like Kentucky. At the very least, even if they don't allow cameras into the courtroom, they should make a they should just make a commitment that they are going to record every public hearing and they're going to publish it, or they're going to make it a public record.
Let me throw this in there. So one reason that I've recently learned that I could appreciate the concept of keeping it private until it's on record. This happened to me in Kentucky. Some of the questions that were asked under oath of me on the stand were to cite out my social security number, my driver's license number, my date of birth, my full legal name, my address, and when I did, they failed to redact it. And in Kentucky, the law is that they redact that stuff. But needless to say, you got a whole audience there listening to all of my private legal information, which, Craig, that was extremely uncomfortable to give in the first place, much less
I bet
it did get abused. You know what I mean? It did get misused. But here's the thing. So Indiana does not have a doxing law in effect yet. They're working on one, but they don't have one yet. And in that, I just recently learned that more of our private information was recently released through a public records request. So it's like, Indiana, do you really care about that? Like, what's your real purpose behind?
Well, look, to be honest, they don't. And the public agencies, they have so much discretion in releasing it. And like, let's keep it real. The prosecutor for any county, city, agency employees, it's the AG, and the AG just doesn't care to prosecute if they screw you over. You know what I mean? Like, being realistic, they just don't care about you as much as they care about themselves.
Yeah, the legal system is super tedious when it's against you, but when it's in their favor, they're lenient as hell.
Oh,
about the rules.
Yes, absolutely. So, like, for example, I ran a story on, I think it was my Craig Henry channel a few months ago, where this cop comes onto my parents' property while I'm just hanging out there with my son, and this guy puts me into cuffs and whatnot. So anyways, I go request the phone calls from like what precipitated this event. And I got the phone calls, and there's this woman who goes and she gives like her address, her name, her phone number, everything. And I just thought to myself, wow, how shoddy of them not to redact that. I'm not going to either.
No, okay. So in Indiana, is it that you received a record in Indiana with all her private information like that?
Well, I mean, you could find it out, but people would prefer it to be private.
Right. So in other words, you just verified it's more than one case. So it's not like my circumstance was all by its lonesome. It happened with the case that you're aware of too. Indiana don't give a shit about the reason, the purpose for that rule. That's what we're proving here in this conversation. They don't care about the purpose behind that rule.
No, as a matter of fact, we've seen, I mean, just while you're on the panel, we're going to wrap this live stream up here soon, but I am going to get this up. And this is something that only the people that have watched till the end are going to have the pleasure of reading here. But they just amended the criminal trespass law with this new House Bill 1338, I believe. And I was talking about it before they passed it on the Craig Henry and the Henry channels, but they passed it, and I was trying desperately to get a hold of my senator and everybody else's senator, trying to say, hey, look, someone needs to come in and give a solid opposition to this bill. But nobody let me, and nobody even answered me. Nobody ever bothered returning my calls. So they just passed it through the Senate, and the governor signed it. Nobody even cared. But let's see here. They go, here we go. Oh, no, this isn't it.
This is Indiana trespass you're referencing?
Yeah, this is the Indiana trespass. And I think, this is section 2. I don't know what the heck I'm doing on section 2. I don't know why Justia shows all this nonsense. They can't just bring up the full code. Let's see if I can find it here.
I didn't know you had a twin brother.
Yeah, he's on the other end right now. He needs to fix his green screen, though. I'll tell you that. And get that thing working. You know what? Since it was just updated so recently, I don't know that. Oh no, here it is, right here. Okay, I've got it. I'm gonna bring it up on the screen. This is so crazy. Let's see. Right here. Okay. So they go, a person has been denied under subsection B1. Subsection B1 is, let's find it. A person who not having a contractual interest in the property knowingly or intentionally enters the real property of another person after having been denied entry by the other person or that person's agent. Okay, so this is B1 that this is supposedly applies to. And he goes, when the person has been denied entry by means of personal communication, oral or written. Okay, and but then they go on to say, well, goodness, this is so convoluted. Sorry about this, everybody. They have a section on public property.
Is it B7?
Yeah, it must be B7. Let's see. Not having a contractual interest in the property, knowingly or intentionally enters or refuses to leave the property of another person after having been prohibited from entering or asked to leave the property by a law enforcement officer. When the no, this can't be it. This guy, I don't know if this is, it's current as of 2024.
Well,
I'll have to find it and make a proper video on it. But basically, what it is they say that, you know, if a police officer tells you to leave a property, public, private, doesn't matter. If they tell you to leave and you don't leave after they have personally communicated it to you orally, you are guilty of trespass unless that piece of the property is otherwise publicly accessible. So they leave it extremely vague, and I'm going to have to find this portion of the law. But they say, yeah, if it's not otherwise publicly accessible. So I don't know how broadly they're going to try to interpret this, but they're going to try to say, like, you know, maybe if you're walking through somebody's employee-only parking lot and a cop tells you to leave, even if it's like a Target parking lot, right? No Target employees ask you to leave. That's going to be enforceable as a criminal violation or trespass.
Well, as I understand, in subsection B7, there's pretty specific detail about the lawful, like if they have a lawful reason to tell you to leave.
Yeah, that's in B7. That's
right.
in B7. So
but that's still there. They didn't amend that out.
No, but that only applies to B7. So that would be designated by a municipality or county enforcement authority to be abandoned, an abandoned property or structure, or an unsafe building or an unsafe premises.
Yeah, I might be citing the wrong sub, but it specifies that, you know, the officer has to have a reason to tell you to leave. You know, basically, as long as you're following the conduct of, you know, the rules that apply under the limited public forum, you know, it's saying the officer pretty much has to have, well, not pretty much, the officer does have to have a lawful reason to request you to leave. I mean, we've argued that to the point here, you know, in Southern Indiana. I mean, they just throw their hands up because they know they can't prosecute because we know that subsection. And, you know, we cite it in person. So luckily they haven't went ahead and charged, but I think that's just because they know the embarrassment that they'll suffer from trying to do so. But I don't know. I mean, you know, I'm always leery when they try to change laws anyway, because they're already, you know, in favor of wrapping people up for things that they're not doing wrong. Like, in other words, the laws as it is are already way too abused by the government, you know, and they know them way better than the people. You know, and the messed up thing is that we the people can be victims of crime all the time, and if anything even ever happens, it's slow. And it seems like they just can't figure out which statute to charge under. It's everything's a civil matter, civil matter, civil matter, civil matter. Even when you clearly show them this is the law that I'm telling you they broke. Here it is. Here's the proof. Here's everything you need to prosecute. You got to do their job for them to get them to prosecute or to charge.
Yeah, and even then they don't prosecute. I know the
Right,
prosecutor in this case. My first video I ever posted, I wasn't wearing a mask in a public building, and this guy comes and he pushes me out. This sheriff comes, and he pushes me out of the building. So I go to the prosecutor. I'm like, "Hey, what are you going to do about this?" And basically, they say we'll go to the state police and have them do an investigation. So we got the state police there to do an investigation, and they did an audio and video recording of their, talk with me. But when they investigated the sheriffs, they didn't think that was necessary. They just kept it, they just took some notes. And then they doctored their report in such a way. But then the prosecutor actually opined on the situation. He goes, Mr. Hendry's conduct is just there, he's just there to agitate public officials for clicks and views.
Therefore, we can commit assault, and it's no big deal.
Yeah, let's be real. He's trying to run a YouTube channel here, so of course we can assault him.
Assault him. Let's assault him. There's a YouTube at stake.
Yeah, it's no big deal. So that's what this prosecutor thinks, and I'm going to bring that up in the hearing as well, because there's something that I don't know exactly what's going to happen. But if we have any type of court hearing, the prosecutor that basically entered himself as a witness to this, this alleged contempt of court. So this guy's made himself a witness. So if he wants to have a hearing on it, as far as I'm concerned, you better be prepared to take the stand and give me some answers.
Yeah, I haven't been to the one that we filed yet, so I don't know. William was lucky enough to kind of cheat the court rules and get it moved at the very last minute, and so we haven't actually been to court for a motion to show cause yet. But I would suspect that it's like any other hearing process, that you have the ability or the rights to examination and all that. So yeah, you just have to cross that bridge when you come to it.
When is your hearing?
They moved it to, oh shoot, I can't remember. I'll publish it on my community tab whenever it's coming up.
Do you remember is it like 30 days, 60 days? How far out?
Well, anything out was unreasonable to us because you're talking about a protective order that's being violated on the regular. So, it shouldn't have been able to be moved. But I think it's like 2 weeks or something. I can't remember. I could reference I put it in my phone, but I'd have to switch out of this app. But yeah, I think it's like 2 weeks away, something like that, which, it is what it is. The process is slow for us, we the people.
Oh yeah. Yeah. Well, they've got me scheduled for August 1st. So this show cause hearing for me is going to be happening on August 1st, conveniently one day before my August 2nd pretrial here. Or no, it's just the deadline date for my briefing is what it is. So I've got this post-hearing briefing that I'm going to be presenting with the court, and I would put it up, but I know that the prosecutor will be watching this, and Brent, you aren't going to get a sneak peek at my post-hearing briefing. Well, it's coming on the 30th day, so I hope you have yours ready as well.
Can I do a shameless kind of a plug here?
Go ahead,
in relation to my interest in what we're up here for right now. I don't know if Craig's told you guys about this, but I'm also facing retaliation court efforts charges, false charges. But and I'm not comparing them. They all suck. Both cases suck for both me and Craig. But mine is 9 charges, and 2 of them are felonies. It's harassment, They're saying cyber harassment. They're saying intimidation of participants in legal proceedings. It's all so ridiculous. But what it boils down to, and this is, I don't know if I updated you on this, Craig. So, I was indicted on the 3 most recent charges, the one that I got extradited for.
Yes.
And I went to that hearing the other day, and I left laughing. We're laughing at it. I mean, even though it's serious, the 2 felonies, we're laughing at it because the charging documents. This is, when you go to an arraignment hearing after an indictment, the purpose of the arraignment is to let you be aware of why and what they're charging you for. So I got those documents and they put them in my hand while I'm in the courtroom and I'm reading them, and it was almost like if I had coffee, I would have spit it, because it says the purpose for the 2 felonies and for the misdemeanor is because I published it on a YouTube channel, on a specifically monetized YouTube channel. Because I published on a monetized YouTube. That's the reason. They said you committed a felony because you published on a monetized. They didn't say what I published. They didn't say that how it was illegal.
They didn't even bother saying what?
No, it literally just says the reason is published on a monetized YouTube channel. All 3 of them in that respect. So, like, they can't even present their reason for indictment. I mean,
well, how are they claiming that it damaged them? Are they claiming that you violated somebody's privacy or something?
Well, the probable cause in the original, right? Because I was obviously arrested and extradited on the original.
Yes. And you spent how many days in jail?
Well, I fought extradition, so it was like 14. So 10 of those,
that's
or no, I'm sorry,
that's
like
a lot of days in jail. That's too many days in jail.
Right. But again, I fought extradition because I knew better than to go to the jail where there was an obvious conflict of interest. The person who's, claiming himself as a victim is the elected official over the jail that I would have been in had I went ahead and extradited. His intention was, they were saying it on their YouTube channel. They were saying that they were going to purchase honey buns for the inmates to have them beat me up, right? So, although I wasn't scared of the inmates, I don't know what that, when you're in jail, you're completely vulnerable to the COs and stuff. So, I wouldn't going to put myself in that position. They're stupid. So, I fought extradition. So it was 14 days. However, the PC on that, right, on these 3 charges that I was indicted for, the probable cause, it's because I made a thumbnail of the elected officials cartoon, like I remade his head into a bobblehead cartoon figure and put it inside of a Ku Klux Klan outfit, like a cartoon movie, an old cartoon movie with, I think, not Dan Aykroyd, but the guy that was on Rosie O'Donnell. I can't remember, Dan something. A movie that he's in, and I replaced I did a face swap with the cartoon bobblehead of the jailer in that outfit, right? So that was the thumbnail. Yeah. So his argument in preliminary was, they asked him how that was a threat. And he, so I'm being charged for a thumbnail. I'm being charged with 2 felonies for a thumbnail. And he's saying, well, the Ku Klux Klan, that's the reason. And again, they're like, what do you mean? So, and he said, well, they date back to 1876 and, they have a history of blah, blah. And again, how does that threaten you? So he couldn't provide an answer, but that is why I was charged with the felony, was because of making that thumbnail. And now I've been indicted on it because they're saying I published that thumbnail.
Right.
Which is also not illegal.
What we have, well, it's not only not illegal, it's protected. What we have here is Section 8 of the Kentucky Constitution. This is the Bill of Rights. This is Section 8 of the Bill of Rights. Freedom of speech and of the press. Printing presses shall be free to every person who undertakes to examine the proceedings of the General Assembly or any branch of government. And no law shall ever be made to restrain the right thereof. Every person may freely and fully speak, write, and print on any subject. And I don't know what the heck that's supposed to be meaning. But not only that, we've got something that's very interesting. Section 9, the next section, is truth may be given in evidence for prosecution for publishing matters proper for public information. And this goes in prosecution for the publication of papers investigating the official conduct of officers or men in a public capacity, or where the matter published is proper for public information. The truth thereof may be given in evidence. But this is for libel. I don't know if they're saying that you in any way committed libel against them.
Well, it's
But
not a civil case, and if anything, it would have needed to be filed in civil court. That, like, what they're alleging is obviously, it really is a civil matter. And the thing is, he would lose in that because free speech, he's government,
yeah,
I mean, I don't know. It's just silly. And it goes to show that these charges that people like Craig and I are receiving are clearly retaliation charges.
oh yeah, yeah.
They're
But I mean,
retaliating
and we're at
because
the
we have YouTube channels.
yeah, we're at the point in the country, in our country now, that it's becoming increasingly dangerous to speak out about government or oppose any kind of government in any meaningful way. There's a lot of people who just say, oh, I don't like the government, or, I don't appreciate my government. Taxes are too high, but they toe the line. They go along with it. But when you get people that actually start to challenge stuff and ask the question, when they're told to jump, instead of asking how high, the question is why.
Yeah.
And the response then becomes no when you don't receive a acceptable answer for why. And this is the consequences of it when you have just a conscience and you decide to act on your own accord instead of the government's.
Mhm.
But with that being said, I think that we're going to wrap it up. And what I want to make it, I haven't really opined on Chris's situation on my channel all that much. I did a little bit when he went to jail, but that was quite a while back. I think that was a few months ago. But Chris is going through a terrible situation in Kentucky, and it's a really challenging thing for him and his family. And I'm personally disappointed in a few people that have been blinded by hatred for this man who really hasn't wronged anybody. Let's be completely
Well, and I didn't
honest.
lie about anything either. That's, I've been having to wait until, the final hearings are completely done. Like everything's done, it's like the lawsuit, I'm not going to talk about the details of the lawsuit until it's over. But like all these people that have said that I lied because of a video made by another YouTube channel, I'm going to be proving the lies that they did to be able to suggest that I was lying. So yeah, I'm going through a lot of people saying that I was lying about the why. I mean, just think about that. Why would someone lie? Why would anyone lie over one single joint from 1998? Like, what? Who would lie about that? I certainly
Well,
didn't.
I'll tell you, I know it's not you. I mean, it's just my personal position on it. I know that you wouldn't be lying about a joint from 1998 because you've personally admitted to things that other people would have bigger issues with than that. So I don't see why you would be lying about that and telling the truth about other things.
They had to take my content and mix it all up and then make actual fabrication, alleged things that were not true in the videos to be able to say that I was lying. And I'm going to be able to prove that they were lies, which is fine by me. But in the meantime, yes, I've lost a lot of support. I've got a lot of people who under their breath, they might, I don't know, disagree during a talk or something. And they'll go, well, you're the guy on YouTube everybody's calling a liar, So I'm sick of it. I mean, but then again, I got some thick ass skin. So, whatever.
And ultimately, man, the truth will set you free. That is what is going to happen in this case. It's just that with the gears of government grinding, ever so slowly, it takes a long time to get that gratification that you're looking for, but we know that it will come. So if anybody is wondering what's going on over at his channel, he's got a lot of conclusive videos that let you know exactly what is happening with him. And if you're interested in seeing government wronging people in the United States in real time, that's another good place to go find this kind of content. This stuff happens all over the place. I think there's countless names that we could name. I know there's an email list that most likely includes you, Chris. That's just like, 400, 500 names, and they're all freedom fighters from all over the country. Mm-hmm. And so they're all over. But this is what's going on in Indiana, Kentucky. We're in the Midwest. So I know there's a lot of people in the chat that are from that same area. But with that being said, we're going to wrap it up. We've got this guy, Doc Savage, in the chat who says he's going live right after this. So if you're interested in joining Doc Savage, go over to his channel. He's been commenting in the live stream. We are going to head out. Chris, you want to say anything before we go?
Well, just thanks for having me up, man. And I miss all of you. Haven't seen everybody, haven't seen everybody in a little bit. So I know I've been kind of quiet lately with all the court stuff going on and Tiffany, starting law school and all that. But
congratulations, man. That's awesome.
Yeah, I'm very proud of her. But yeah, we've been awfully busy and I haven't been able to spend as much time with this family as I like to. So just want to let everybody know, I still love everybody and I miss you.
Yeah, absolutely. And thanks for coming on. And as far as announcements go, I mean, I've neglected to announce it to the world. It's very private, but I do want to announce it. The reason I haven't been coming around is we actually just welcomed our second child into the world. We had a little girl, Sophia Leah Hendry.
Congratulations.
So thank you. And she is just a beautiful young girl. So I've been taking care of her, but the reason I'm up here in the studio tonight is I have court tomorrow in Lake County. So we're going to see how that goes. And then hopefully after a week or two, I can kind of get back into making some content for everybody. So with that being said, Doc Savage is going live. We'll see you over there and we'll see everybody later. Bye.
Later, everybody.